Global happenings today. We communicate. We analyze global news.
You brought the cameras? Is that why you brought them today? You didn't bring it before? You brought it today? Show me where it says you can try me on a repeat law. Show me. Show me where it says you can try me on a repeat law. I said, show me. Show me. Show me. No, leave it. Leave it. Leave it. I said, leave it. It's a court of law. I'm under trial. I'm under trial. I have to speak. I'm under trial and I have to speak. Listen to me. Listen to me, please. I'm under trial. I'm under trial. I'm under trial. And I must address the court. Wait. No, listen to me. Please. The judge must listen to me.
Now, this is one of the issues that Nnamdi Kanu had been putting before the judge to show him where there is provision for him to be tried on an repeal law. Don't forget that he's been tried on the Terrorism and Prevention Act of 2013. But a new one came up amended in 2022. And that's where there's issues. But let's listen to Omotosho as he took out time to detailedly show everything. And from there, when we're back, we'll discuss more.
Assuming without conceding that at the commencement of the Terrorism Prevention Amendment Act, the Terrorism Prevention Amendment 13 was repealed, and such is liable to affect the validity of the defendant's trial. I refer to Section 98 of the Terrorism Prevention Amendment Act 2022, which provides 98.1. The Terrorism Prevention Act number 10/2011 is repealed. 2. Any regulation, order, requirements, certificates, notice, direction, restrictions, authorizations, consents, applications, ongoing cases in courts, requests or things made, issued, given or done under the Repeal Act shall, if enforced at the commencement of this act, continue to be enforced and have effect as if made, issued, given, or done under the corresponding provision of this act. 98.3 provides any proceedings, prosecutions, sentence, judgments, charge, or course of actions pending or existing immediately before the commencement of this act under any of the repeal acts in respect of any rights, interest, obligation, or liability may be continued and commenced as the case may be, and any determination of any court of law, tribunal, or other authorities or person may be enforced to the same extent that such proceedings, prosecutions, sentence, judgments, charge, course of actions, or determination might have been continued, commenced, or enforced as if the act has not been made, unquote. The imports of this provision, particularly section 98.3, it serves as a saving provisions which ensure that the amendment of the act does not affect the validity of trial begun under the Repeal Act. This saving clause or preservation provision is aimed at ensuring that pending proceedings or order of court are not washed away as a result of the commencement of the amended Act 2022, but to ensure a smooth transition from the Repeal Act to the amended Act. The sum total of this is that the enactment of the Terrorism Prevention Amendment Act 2022 does not vitiate the trial of the defendant rightly commenced under the Terrorism Prevention Amendment Act 2013. Consequently, this issue is resolved against the defendant.
All right, welcome back. And if you listen to Omotosho very well, he took our time to point out the provision under the new act, that's amended act, where cases are meant to continue, whether they were started by the old one or new one, since they are already in court. It should go on, nothing hindering it. And I think this would have been the duty of his lawyers, that's to give him, yes, his consultant would have given him more in-depth on the provision of the Terrorism Act, as amended Terrorism Act, for him to know that, something like that exists. Because I believe if he had known this, they would have concentrated on the defense, starting up the defense, and on the basis of that, maybe possibly prolong the case. But because for some reason, I don't know why his legal consultant didn't do their own researches, because I say maybe they are not criminal lawyers. That's why they did not know all of that. My colleagues in the house, what's your standpoint on all of this? Nigerians are really talking.
The truth be told, I understand the pains of Nnamdi Kanu now. Even though if you're listening to the verdict as it's going on, you will notice that Nnamdi Kanu's case has been sealed.
Yeah.
I already have an idea. The only thing is that we just want to know how many years are we looking at here. Now, then again, I will also not blame the lawyers so much, because look, law is broad just like medicine is broad, just like ICT is broad. You choose which one you're specialized on, or else you're going to make a foolery of yourself. Now, for medicine, you cannot be a surgeon and still be a gynecologist and still be a dentist and still be a physician or still be a pediatrician. It's not possible. You have to choose one specialty and become a consultant in that field. I believe that Nnamdi Kanu's lawyers probably are not a specialty in criminal law, because new cases may be coming in, adjusted acts, repelled acts, and new ones are coming in. You may not know because you have not specialized in that field. That law can be so broad that there's some new ones that come like, you're not vast in it, because that's not your specialization, your area of specialization. I feel that at this rate, I don't know how his lawyers will be feeling right now, knowing fully well that they just hampered on something that has leakages that can be used to nail their clients. But then again, don't forget that Nnamdi Kanu is defending himself. So
defending yourself, irrespective of the fact you are defending yourself, they will just give you an opportunity. That was why I think James Omotosho was suggestive of the fact that he needs to get someone that can make recommendations for you. But I think Kanu Gami was the best hand, because at least we know that this is the senior advocate of Nigeria, and he had trail of victories in criminal cases. So I think he was the ideal person to handle it.
But I also believe that it could be a case of funds and finances, because I could still remember when Barrister Okpara was talking to him some 3-4 weeks ago about the issue of funds. He talked about meeting with the IPOBs. But that's where we're going to wrap it up.